Well, hello there. Thanks for joining me. I am Dr. Jen, and this is my life as a landlord. I am so pleased that you're joining me for today's show all about Nunavut. Nunavut, the Canadian Territory. This is, of course, a location-specific episode, and this, like all the other ones, I've included hyperlinks in the show description, and so you can go right into Nunavut's tenancy laws, all kinds of information about residential tenancies in Nunavut. And I'm going to go through that with you today. Right now, what I'm going to do is I'm going to screen share. So if you've not seen me do one of these before, if you're best be watching on YouTube if you want to follow along on the screen share. And here we go. I'm just going to there. Okay, here we go. So this, if you go to my first hyperlink, Residential Tenancy Act of the Territory of Nunavut, you've got, of course, remember, a tenancy law is a law. And so this is the actual law. You can download it, and it is quite legal. What do you know? Because it's a law. And it goes through all of the details, and it's not usually very user-friendly. Sometimes it is, but this act is only 58 pages long. That's actually not too bad. I've seen way worse than that. And it goes through everything that you can think of. There's a couple items that I think are not addressed, but that's okay. We'll go through it. So that's the first one. So if you want to read the law itself, you certainly can. But now I'm getting ahead of myself. Hang on a second. I gotta give you my disclaimer here. Yes, here's the intro. Each of my location-specific podcasts are set up in the exact same way, answering the same four questions. What are the basics of the Nunavut Residential Tenancies Act? What are the nuances of this location? What's different and what stands out based on me doing research on all kinds of other locations? 3, some guidance about abandoned items left behind by a tenant, and then where to get help in your local area in Nunavut. At the very end of the episode, I'll go through what I call my bingo card, which is my list of items that I have seen most frequently defined in different ways. And so I'll make sure I'll go through my bingo card and just see what is the standard items that I see. I also have to give you a disclaimer that there may be more guiding documents in your extreme local area. And so, and of course, 5 minutes after I record this podcast, things change, right? Bylaws change, laws change. So make sure you are keeping yourself active in your local area. This episode is not all inclusive, and you must research further on your own for your own specific rentals in your specific area. But today's episode will at least get you started. I want to also give a plug for today's sponsor, Aloha Capital Investments, LLC. If you want to know more about real estate investing, check out alohajv.com. Okay, now I can go into screen sharing. Here we go. So we've got this one, Nunavut. I only have 3 hyperlinks that I could find that was really good sources, hyperlinks for you to get started on your residential tenancy items. Other locations, I found many more, but Nunavut is a relatively small population in that area, and I have a feeling that's one of the reasons why things are a little bit more consolidated, which is why there are such few links. So let me go to the second one. This is, oh no, that's the third one. We'll go to this one, Nunavut Rental Office. So the Nunavut Rental Office gets involved with a rental officer to receive, investigate, mediate, and settles complaints under the Act. If there's a landlord and a tenant dispute, then residential housing rentals in Nunavut, this is where you go, is the Nunavut Rental Office. But it does not include housing owned by the federal government. So this is all provincial, local, individually owned. And a couple more items that they talk about, and it looks like they like it for you to email them, but what they really talk about is they say the office can provide information about all other residential property in Nunavut, including how the Residential Tenancy Act works, obligations of both landlords and tenants, repairs and maintenance of rental units, renewal or termination of tenancy agreements, security deposit, and then differences with staff housing, private rentals, public housing, things like that. And so what they really like you to do is call them or email. So if you're going to email them, it's rentaloffice at gov.nu.ca. And if you're going to call them, toll free 1-844-975-6314. It's kind of cool. And if you've ever had a question or you've never phoned one of these organizations before, they're amazingly helpful. This is the language that they speak, is residential tenancies. So if there's any question whatsoever, pick up the phone and call them. I do this quite often in the locations where I have rentals, and I'll just say, you know what? I'm not really sure. I've Googled it. I don't know the answer. Maybe one of these folks knows. And guess what? Chances are very good that they do. There's either a precedence or there's a change or something they can help you with. So, but I was hoping there would be some more hyperlinks on this particular website, and there isn't, but that's why I say if you really have more information or you've got really more questions, then you just need to either email them or call them. Okay, but then this is the third hyperlink that I provided. This is tenantrights.ca, and then this is all about Nunavut, tenant landlords and rights in Nunavut. And so this goes through some of it. Now, I would usually go through a user's guide, but they don't have a user's guide. This is sort of instead of a user's guide, but it helps you go through it, which is okay. But again, there's might be some more local slicks. There might be some more local brochures in your area that can help. But let's go through this. Talks about types of rental periods, whether week to week, month to month, fixed leases, which tenancy ends on a specific date, right? It does end abruptly. A signed lease is not required. However, if you've been a listener of this show, you know that a written tenancy agreement is ideal. It's not required by law, but written rental agreements is a way to avoid headaches and hearsay later on. Is a signed move-in, move-out inspection report required? Yes, but only in the event that the landlord requests a security deposit from the tenant. So if you're not going to request a security deposit, which I'm sorry, I've never seen. I always have a security deposit for every tenant. But if you're not going to request one, then you don't need a condition inspection, because the only reason that you're going to request a security deposit is to compare the condition inspection at the move-in and then at the move-out. So if you're not going to request a security deposit, you're basically taking it as is when they leave. When a security deposit is requested, the landlord and tenant sign an inspection report at the beginning of the tenancy together. Okay, let's talk about deposits. Deposit cannot exceed the amount of 1 month's rent unless the property is being rented on a week-to-week basis, in which case the total amount cannot exceed the 1 week's rent. Landlords that rent out the subsidized housing may use true market value of rent when calculating security deposit. So yeah, if it's different, it's subsidized. Okay, so here's an interesting aside for a security deposit. If the tenancy is more than a week-to-week period, the tenant may pay half of the security deposit when moving in and the rest over 3 months, but not more. So you want to make sure that if you're doing a security deposit, okay, so wait a minute. If the tenancy is more than a week-to-week, you don't have to pay the security deposit all up front, is the point. But the landlord is required to return the security deposit to the tenant with interest, 10 days after the tenant leaves the rental property, and the rate on the security deposit interest is calculated at a rate equal to that of a chartered bank deposit rate on deposit receipt for 30 days as determined by the Bank of Canada in Bank of Canada review. If this is confusing, call the tenancy branch, the rental housing folks in Nunavut. They will help walk you through this. The interest rate starts to take effect on the first day of January in the year that the interest begins to accumulate, and the landlords are legally obligated to give the tenant an itemized statement of their account for any part of the deposit that they wish to keep, meaning if you're going to deduct some items. So first of all, you better have done a condition inspection at move-in if you're going to deduct anything at move-out and you're going to keep it. And if you are going to keep it, then you've got to submit an itemized list. Now notice you do not have to submit invoices or receipts. It just says an itemized statement of their account. Some locations you have to actually provide invoices and cleaning receipts and things like that. In Nunavut, you do not. A landlord is able to retain all or part of the deposit collected from the tenant for rent arrears, as well as paying for willful damage to the property. So you can use the security deposit as last month's rent. You can do that. Key money. Oh, this is interesting. It is illegal for a landlord to require a tenant to pay key money. Basically, this is I hate to say it, it's a bribe. There are locations, not in North America, but that do key money, where it's just a landlord, wants to pocket money. Any other type of deposit other than a security deposit is completely prohibited. So notice anything regarding pets, you cannot charge an additional deposit. It's just a security deposit, right? But no key money. Post-dated checks. I've seen this in other locations as well. Look, landlords have the right to request post-dated checks, but tenants don't have to comply with the request. I actually provide multiple ways to pay rent in my locations, because my locations are in the US and in Canada. So I provide several different ways that people can pay rent by their choice. But it doesn't have to be post-dated checks for me. And so you're not allowed to require that. Okay. Renewing a lease in Nunavut. When a tenancy agreement comes to an end on a specific date, remember, if it's a fixed lease, it is going to end abruptly. And if a new year-to-year a tenancy agreement or notice to terminate was not provided to either party, this is now called a holdover. The landlord and tenant must renew the tenancy agreement on the date specified in the lease as a month-to-month tenancy. Basically, they're saying if you're not going to sign on a new year lease, you must sign a month-to-month lease, right? So it doesn't have to be in writing, but you know how that goes. Okay. Term tenancy agreement is automatically renewed on the expiration date as a month-to-month tenancy unless a landlord and tenant have entered in a new rental agreement or the tenancy agreement has been terminated in accordance with the Residential Tenancies Act, or the residential complex is composed of a single rental property, which was the only personal dwelling of the landlord in Nunavut. Basically, it's just a single family home and that's the only rental they have. Yeah. Okay, so terminating a tenancy, giving notice and the timing. Before a lease can be terminated, it is the responsibility of both the tenant and landlord to renegotiate the terms or terminate the lease altogether. Landlords can only terminate tenancy for specific reasons outlined in the legislation and cannot terminate simply because the fixed term lease has expired. You can't just end the lease because the lease term has expired. When a fixed term type tenancy turns into month to month, a landlord is not able to force a tenant to sign another lease or agree to another fixed term agreement. So they're saying that it does actually automatically convert to a month to month term. That's a bit contradictory and confusing. When a lease is renewed, unless another arrangement is agreed upon other than the new term of the lease, all other conditions remain the same. Meaning length, who's there, the cost, what's included. Notice of termination from the landlord or tenant has to have these requirements. The notice has to be put in writing and signed by the landlord or the tenant, whoever's giving the notice. The notice has to identify the rental property specifically. You have to actually say the address of the rental property. The notice has to state the date when the tenancy is set to end, and it must have a specific reason for ending the tenancy. If the notice does not follow all those requirements or is not served in the proper way, it is completely invalid and the tenancy stands. In addition, a landlord can end a periodic tenancy in the event that, of course, you sign a new lease in limited circumstances, notice given by the landlord. Let's say they want to move in. The notice is given by the tenant by a legal order, meaning you've begun an eviction and the courts have awarded you writ of possession, where the property is rented to an employee as a benefit of their job, and lawful termination of the tenant's employment, which also includes ending the tenancy of their dwelling as well, or the property is then abandoned by the tenant. Okay, so this is the final bit about ending tenancies. Termination of a fixed term agreement by a tenant must be done no later than 30 days before the end of the term. With regards to a periodic tenancy, one that does not specify a termination date, the following cases can be applied. Weekly tenancy requires 7 days before termination to give notice. A monthly tenancy continued for less than 12 months, meaning you were on a month to month and you're going to continue month to month, minimum of 30 days before the termination. And then a monthly tenancy that has continued for more than 12 months, meaning they've been there for more than a year, you have to give 60 days. Okay. Assignments and sublets. Tenants are able to sublet their property if the landlord approves, and so you have to have the landlord approve. If the landlord refuses to give consent for the sublet, the tenant can appeal to the rental officer and may obtain permission to sublet the unit to someone else. When tenants sublet the unit they're renting, they're still responsible for payment of rent and any violations of the lease agreement committed by the subtenant. For assignments, tenants have to get the approval of the landlord but cannot appeal to the rental officer. When a tenancy is assigned, the former tenant transfers all of their rights and duties to the new tenant because they're basically the new tenant is taking over the lease. A landlord cannot change the terms of the sublease, but can charge up to $50 for expenses that occurred as a result of granting consent for the sublease or the assignment. There is a bit of administration, I will tell you that. We do that, and I don't charge that fee. I probably should. If the landlord consents to the assignment or sublease, it must be put in writing. Okay, well, there you go. All agreements that must be signed by the tenant and subtenant and attached to a copy of the lease. Let's see. Rent increases. Okay, here's where it gets really interesting. Notice and timing. A landlord cannot legally increase the rent for a rental property more than once every 12 months. So once a year. That's pretty standard across Canada. The landlord has to be given a minimum of 3 months written notice of the increase. So that actually it should say the tenant. The tenant has to be given a minimum of 3 months written notice of the increase. On the day before the increase is set to go into effect, a tenant who receives proper notice may treat the notice as termination of the lease agreement. Tenant that wish to terminate the agreement have to inform the landlord in writing, notify them of their decision to move. Okay, fine. The landlord may rent the premises to others, but they're required to keep the rent for the new tenant at the same level stated in the notice. Okay, so that means if you give a rent increase to the tenant, then they give the resulting, as a result of the rent increase, then they give notice that they're going to depart, basically notice of termination. Then if the landlord is going to turn around and re-rent it, they cannot increase the rent. Okay, interesting. Late rent payments. A tenant who pays his or her rent later than the date that's specified in the lease agreement faces financial penalties, and the penalty is calculated for each individual day that the rent is late by multiplying the rent due by the chartered bank deposit rate on the deposit receipts for 30 days. Okay, so this is it's the same calculation for, looks like, interest. The penalty is calculated for each individual day that the rent is late by multiplying the rent due by the chartered bank deposit rate. So that's sort of the baseline interest rate for Nunavut. This is really interesting how this goes. It's not a flat rate, but it is a calculation. And it's per day. Okay, that's interesting. Okay, evictions. If the tenant refuses to leave after being properly served a termination notice or an order to vacate, the landlord is required to obtain an eviction order from the rental officer and register with the Nunavut Supreme Court. Applications for eviction order are required to be served by either party at least 5 days prior to the date that the hearing is scheduled. Both parties involved should have a lawyer present at the hearing. Wow, that means you've got to spend money on a lawyer. Wow. If an eviction order is granted, a writ of possession from the Supreme Court clerk is also required. The landlord delivers the order of eviction as well as the writ to the sheriff's office in Nunavut, and then the sheriff must make a reasonable demand to enter the rental property of the tenant being evicted. If the tenant refuses to comply with the sheriff has the right to forcibly enter the premises. Resisting the sheriff in this case could result in a criminal charge. Interesting. Okay, so it continues on. There's a bit here about access, landlord entry. Landlords have the right to enter the rental premises between the hours of 8 a.m. and 8 p.m. And you've got to give written notice of their intent to enter at least 24 hours before the time of entry, detailing in the notice the time they will be entering and the purpose for it. You can't just go in. And then you've got certain items that you can landlord has a right to enter the premises to do all of these different things. So show the property to prospective renters, prospective buyers, inspect the rental property every 6 months. We are in our units probably more often than that, mainly because we do pest control on a quarterly basis. And so we're in all of our units, at least on a quarterly basis, escorting the exterminator. So that's an interesting way to do it. Landlord has a right to enter. Oh, here we go. Landlord has a right to enter the tenant's rental unit without getting notice when there is an emergency. Now, an emergency is anything that you've got to call 911 for. That's an emergency. If it's just something convenient or aesthetic, or it's not an emergency. It might be an emergency for you in your calendar, but it's not actually something you'd call 911 for. That's not an emergency. So let's go through this again. A landlord has a right to enter the tenant's rental unit without giving proper notice when there is an emergency, the tenant agrees, or the landlord has a valid reason to believe that the tenant is no longer living there, meaning it's abandoned and they're just going to go in. Honestly, I would do a wellness check if that's the case. Okay. May the tenant withhold the rent for repairs. No, this is interesting. The tenant is required to file an application to forward the rent to the rental officer, who will then hold the rent until the dispute is resolved. This does not release the landlord from actually doing the repairs, and this does not release the tenant from paying rent. So this is really interesting that they interject the rental officer as a form of mediation, third party, in a repair dispute. Interesting. Locks to a rental property can only be changed when both parties, both the landlord and the tenant, agree to it. A landlord or a tenant cannot change the lock on any entrance to the residential area of a complex in effort to inhibit or interfere with the other's access to the complex. That's not allowed, you guys. Don't do that. All right, pets and smoking. With regard to public housing units. Now, this is public housing units. This is not it. Let's see. I'm just even going to go right over that. For private rentals, a landlord can refuse to rent to a tenant with pets. Remember, a pet is an animal that does not have a job. A service animal is an animal that has a job. Okay, so let's just go with a pet. If pets are allowed in the lease agreement, or if the lease does not address the issue, then pets by default are permitted in the unit. Can a landlord include a no smoking clause in the lease? Yes. Interesting. Okay, now here's the big fine print. If there is no pets and a no smoking clause written in the lease, and the landlord finds out that the tenant has a pet and or is smoking in the unit, can the landlord legally evict the tenant? Yes, but only if there is a no smoking and a no pet clause present in the rental agreement. So if you're a landlord in Nunavut, you need to make sure you've got this in there to protect yourself if you don't want pets or you don't want smoking. The rental officer who reviews the termination of the tenancy will try to determine if evicting the tenant is reasonable as long as it was potentially interfering with the other tenant's right to quiet enjoyment. The eviction will likely be upheld. Okay. Oh, so this one says, this is interesting. Nunavut's Residential Tenancy Act is based on the Northwest Territories Act, which went into effect in 1988. In an effort to encourage out-of-court settlements, the rental officer is granted numerous powers held only by the courts. The role of the rental officer is to provide information, mediation, and act as a judge as certain circumstances require. In cases where both parties cannot reach an agreement even after mediation, the rental officer must intervene and hold a hearing. At these hearings, a rental officer takes on the role of a judge. The order of the rental officer can then be enforced on the courts. Wow, that's interesting. And again, it gives some information about renting in Nunavut. Yeah, Residential Tenancies Act, consolidation. There's all kinds of items in here. So that's that. So let's go through, this isn't very long here. Let's go through, let's see, abandonment, 62. I have actually been looking at this and I've kind of gone through my bingo card a little bit, and I'm seeing that I don't see a couple of items on here, but I tell you what, let's just go through, let me stop sharing and let's just go through the bingo card, because I think we're going to hit some of these things. Okay, so tenant application fee. It said no key money, but it did not say anything about a tenant application fee. So if you're a landlord in Nunavut and you're wondering if you're allowed to charge a tenant application fee, if you're confused, I would just call the rental officer and just ask the question and say, look, can I charge a $50 fee because I have to check credit, I have to check criminal records, I have to do all these things, and you have to pay for it, right? So that's a maybe. I don't know. It didn't say anything. Is there a grace period for late rent without a penalty? The answer is no. We saw in there late fee is starting to calculate the day after the rent is due. And so there is no grace period. It did talk about how to calculate it. It's an interesting late fee calculation. It's not a flat dollar amount or a max dollar amount. It's actually a percentage of the rent based on a Bank of Canada deposit interest rate. Security deposit method. You do have to pay. It didn't say it had to be in a separate account, but typically that's best practices is to put security deposit money in a separate account, because remember, that's not your money. That's the tenant's money. Lease wording and details. It didn't go into it, and there wasn't a form. So if I was you in Nunavut, steal one of the leases from BC or Ontario and use that as a guide. Or the Yukon actually has great forms as well. You can use it somewhere else, but I would also have it checked by a local real estate attorney in your area, and they actually may have a lease for you there too. So there's a couple different ideas. Is an emergency contact required in the event of a tenant abandonment, incapacitation, death, or imprisonment? No, there isn't anything. Again, another best practice thing that Nunavut should consider adding. Pets and animals, is there a pet deposit or is there pet rent required? So it didn't talk about, it only talked about if you have a no pets clause in your lease, and then that's would be a material term in the lease. And it didn't say anything about a pet deposit or pet rent, but it did say the security deposit can only be any deposit can only be 1 month's maximum. So if you're going to allow pets, then it looks like you can have a pet deposit. About pet rent, I would call the rental officer and say, am I allowed to charge extra if someone has a dog or a ferret or a cat or a bird or something? Is a signed lease delivery required within a certain amount of days? No, but on a lot of other provinces and locations in Canada, you do have to deliver a signed lease to your tenants, and so I'm surprised this isn't in here. Condition inspection at move-in. It is required if you're going to charge a security deposit. Standard warning letters or wording. No, I didn't see any forms or standard warning letters or wording or anything. It was mostly call the rental officer. Required maintenance inspections. It didn't say required, but it said that you could enter for maintenance purposes every 6 months. How often can the rent be increased? Looks like once per year. Proper notice of the rent increase is at least 3 months. How much can the rent increase? Guess what? There's no rent control, which means with proper notice, a landlord can increase it to any amount they want, which is interesting. Is renter's insurance required or mentioned? No. Is abuse of access defined? Yes. There was a specific part in the Nunavut Residential Tenancy Act and the tenant right document that we looked through that did talk about landlord access and how to do it. Is landlord retaliation defined or timing given? And the answer is no. So there was no, if a landlord is trying to retaliate based on the tenants trying to either form a union, they were reporting code enforcement or something wrong with the unit to a governmental agency, and the landlord wanted to either evict them, decrease their services, or increase their rent, that's called landlord retaliation. And none of that was included in the Nunavut Residential Tenancies Act. End of fixed lease, is it abrupt or does it auto convert to periodic? Well, it looked like it was abrupt, and it appears that it automatically does convert to periodic. So it's a little bit confusing, but it does appear that it does convert. Is a condition inspection at move out required? Yes, especially if you have a security deposit, you must get that. Return of deposit or bond timing. Actually, it's just, there's no bond in this one. Return of deposit is, I believe it is 14 days, or maybe it was 10. Let's go back and look. Security deposits. Here it is. 10 days. Within a period of 10 days, a tenant leaves a rental property, you got to give it back. Yes, indeed. Okay. Can you use the deposit as last month's rent? Yes or no? Yes. And abandoned items. There was nothing that I saw in the Residential Tenancies Act for Nunavut about abandoned items. There was nothing about the value of abandoned items, how to do administrative inventory, storage timing, disposition instructions. But as we've seen, if you have any questions, call the rental officer, because I bet they know exactly what they're supposed to do. There's probably some direction on what to do on trying to notify your tenant that they've got items left in the unit, that there is some inventory method you're supposed to do. There is some storage timing that you're supposed to store the items. And then there is some kind of disposition instructions, whether it's a timing of you can throw it away, or maybe if it's a value, you can sell it. The rental officer will very likely walk you through it. I could not find anything about abandoned items in Nunavut. And so that concludes the bingo card portion. So let's wrap up this episode all about Nunavut. Each of my location-specific podcasts, again, is set up in the exact same way, answering the same 4 questions. What are the basics of that location in their landlord housing governing document? What are some of the nuances in that location? What to do about abandoned items that are left behind by a tenant, and then where to get help in your local state, province, territory. Then I reviewed the bingo card of standard items I see most often in tenancy laws in different locations. And this is the same format I use for every location-specific episode. So if you're interested in another geographic area, you already know what I'm going to talk about. You already have the framework. It'll just be a different location. But one more time, I've got to include that this episode is not all-inclusive. You must do your own research. This episode is only designed to get you started. If you're listening to this podcast, chances are you are either new to real estate or you're new to real estate in Nunavut. Things you can do to help yourself are, one, read the Nunavut Residential Tenancies Act. Read the act. It's only 58 pages. It's probably a very quick read. There are other resources I provided, but read the act, get familiar with it. Two, the other thing you can do is you can join your local meetup group in your city, county, regional district, whatever it might be. You can find all of that on social media. You can even join landlord forums in social media and ask questions. The thing is, you want to make sure you get in the conversation with other folks who are asking questions just like you in the province, or sorry, in the territory of Nunavut. I hope you enjoyed today's show all about the Canadian Territory of Nunavut. A kind reminder, if you haven't already, please subscribe and follow My Life as a Landlord. Much appreciated. Today, I'm recording this episode on my boat in Desolation Sound, north of Vancouver, British Columbia. Why? Because real estate takes you places. Where do you want real estate to take you? Join me in the next episode live right now in the library, episode 168 about the great Canadian province of Quebec. I'll see you there.